Hello, everyone. My name is Ariella Wagner. I'm the founder of SunRay Construction Solutions, a national construction document service. We help thousands of general contractors, subcontractors, and suppliers secure their lien and bond claim rights. Today, we have a fabulous webinar conducted by Kevin Estevez. He is a member of Holden Willits, and he is a brilliant construction law attorney. So today, without further ado, I would like to introduce Kevin.
Good morning. Hi, my name is Kevin Estevez, and I'm an attorney at Holden Willits, as Ariel said, and I'm happy to be talking to you all today about getting paid faster in Arizona with liens, bonds, and contracts. And so first, welcome to the webinar. If you have any questions, please use the GoToWebinar chat box on the right-hand side of your screen, and we will get to those at the end. And please do not include company names or your individual names in the question. And with that, let's get into the subject for today, which is getting paid faster. In Arizona, as in probably most states, contractors and suppliers have several remedies in the event of non-payment. Those primarily consist of mechanics liens, bond claims, contract claims. Bond claims and mechanics liens, depending on the nature of the project, are two of the most effective sources of getting paid and getting paid faster. Contract claims can also be effective. Arizona has also potential, depending on the situation, non-payment claims that can be filed with the Arizona Registrar of Contractors, and other potential remedies. But we'll talk mostly about contract claims, mechanics liens, and bond claims today. And so first, the first step to getting paid faster is always to negotiate a favorable contract. And I know that sounds pretty rudimentary, but the basis for nearly every relationship in the construction industry is in the contract that the parties negotiate, whether it be the prime contract that the general contractor enters into with the owner, or the subcontract that the general contractor enters into with a particular trade, or the credit agreement that a supplier enters into with a trade. So with respect to terms of a construction contract, as is reflected on the slide here, A.R.S. 321158A sets forth 9 minimum elements that every construction contract must contain. When I say every construction contract, I'm referring to prime contracts. And those are general requirements like date of completion, payment terms, payment schedule, things of that nature. Interestingly enough, while 321158A does require specifics in terms of contract terms, if those specifics are not included within the contract, the statute specifically says that that does not render the contract unenforceable. But aside from the minimum elements you would need in a contract, and some of them will affect payment, there are numerous provisions that you can, as you can imagine, in construction contracts or credit agreements that can affect the timing of and the ability to collect payment, including payment terms, including claim notice provisions, interest provisions. If payments aren't made in a timely fashion, what interest is going to accrue on those. Dispute resolution clauses. If there's a dispute over something that happens on a project, how does that play out? Are there informal negotiation procedures? Is there a mandatory mediation? Is there alternative dispute resolution in terms of an arbitration that is ultimately going to decide the dispute rather than proceeding with a civil lawsuit to collect payment? There's also more specialty clauses that can pop up, such as no damages for delay clauses, pay if paid provisions, and attorney's fees provisions. So all of these things can affect the the ability of a contractor or supplier to get paid, and they're all things that need to be carefully looked at in entering into a contract. And each of these subjects could really, you could spend a whole webinar on these topics, but for purposes today, we're just going to touch on them briefly. One thing to keep in mind too is Arizona has a Prompt Pay Act, and Arizona was at the forefront of instituting prompt pay acts back in the day. And Arizona's Prompt Pay Act will likely govern payments on all projects lasting longer than 60 days. So let's touch a little bit on Arizona's Prompt Pay Act. Arizona has both private and public sector prompt payment laws. A.R.S. 6924 covers ADOT projects. Then you have A.R.S. 412577 state projects, and A.R.S. 34221. Those are city, county, and improvement district projects. And those, so these are the prompt pay laws that cover public construction projects. A.R.S. 321181 at SEC is the prompt pay laws that govern private construction projects lasting more than 60 days, with the following exceptions. So the two main exceptions are the Prompt Pay Act will not apply to residential. And when I say residential, I mean owner-occupant projects if the contract with or invoices to an owner-occupant do not contain a notice that the prompt pay law applies. And the idea behind this is that people that are entering into contracts for construction of homes that they live in are perhaps not as sophisticated as the folks that work in the construction industry on a regular basis. And so if the prompt pay statutes are going to apply to their projects, it needs to be spelled out in the contract so they have some sort of frame of reference. So owner-occupant projects that last longer than 60 days, the prompt pay statute will apply only if it's specifically, there's a notice in the contract that says it applies. The prompt pay statute can be opted out of in any construction project in Arizona, even those lasting longer than 60 days, but it is a rather onerous process, and consequently it is not done very often. So as you see here at the bottom of this slide, the parties can alter the billing cycle by, number one, you have to provide a different payment schedule in the prime contract in a clear and conspicuous manner. And then two, you have to place a statutory notice of alternate billing cycle on every page of construction and bid plans. And the idea behind this is if you're going to use a billing schedule that differs from what the prompt pay laws provide, you have to let everyone on the project know so they can alter their expectations. And the idea of placing the notice on the plans is to give those trades that are going to be working on the project and bidding the project notice up front that the billing cycle is going to be different from what they typically encounter. So as I said, it's a fairly onerous process, and as a result, it's not done very often, which means that in most cases, if you have a private construction project that's not residential, Arizona prompt pay laws are going to apply. And that's irrespective of what is in the contract. So what is Arizona's Prompt Pay Act? What does it provide? It generally provides a standard billing cycle that is 30 days. And in that 30-day billing cycle, it's broken down into several different key dates or milestones. The first is that once an owner receives a pay application from a general contractor, they have 14 days to review and object in writing to the contents of the payment application. If they do, then that objection is noted and preserved. If they don't do anything within that 14 days, then the pay application is deemed certified and approved. And that gets us to the next step, that once the payment application is certified and approved, the owner has 7 days to pay the general contractor. And subcontractors then have, or the general contractors then have 7 days to pay their subcontractors. So we have a 14-day time frame to review and approve. 7 days after that for the owner to make payment, and then 7 days after that for the subcontractors to get paid from the general contractor. If, like I mentioned before, the objection to a pay application has to be in writing. And the Prompt Pay Act also provides that interest will accrue on all paid sums at 18%. And it also provides a mechanism for recovering attorney's fees. So the first step is to enter into, as I said, a favorable contract. The second step, and going back to that first step, bear in mind that the prompt pay laws are going to most likely apply to the project, and know those. And as I indicated before, you could spend a whole webinar or perhaps more on Arizona's prompt pay laws. And so there's different other mechanisms in the statute that assist contractors in getting paid, and can be very effective and helpful. The second step is to serve a preliminary 20-day notice. And this is something that we've covered on these webinars before, but except for labor for wages, every lien claimant and some Little Miller Act bond claimants in Arizona must serve a preliminary 20-day notice within 20 days of beginning work. If you don't serve a 20-day notice and you're a lien claimant, you forfeit all lien rights. If you're a bond claimant, you may forfeit your bond rights. If you do not timely serve a 20-day notice, you can forfeit a portion of your lien or bond rights, and we'll get into that in a little more detail. So it's really important, if you want to preserve your right to payment, to, in Arizona, at least serve a preliminary 20-day notice. And these, I've got a quote here from Del Mastro and Els versus Taco Bell. And there the court says that the 20-day notice are designed to give the owner advanced information of the identities of any unpaid claimants who may perfect liens against the property if their debts remain unsatisfied. So the whole purpose of 20-day notices is to put owners on notice of the folks that are performing work on their project, that are performing work, and give the owners an idea of who may be making lien claims in the event if they're not paid. We've talked about this before, but the contents of Arizona's preliminary 20-day notices can be found in A.R.S. 33-992-01C and 33-992-01D includes a sample 20-day notice, and the preliminary 20-day notices that you serve must substantially follow the statutory form. Once you have a 20-day notice completed, it must be served on the owner or the reputed owner, the original contractor or reputed contractor, the construction lender or reputed construction lender, and the person with whom the claimant contracted. And it should be addressed to the recipients at their residence or business address and served via either first-class mail with a certificate of mailing or registered or certified mail with postage prepaid. And 20-day notices are deemed served when they are deposited in the mail. So I talked about potential waiving a portion of your lien or bond claim rights if you don't timely serve a 20-day notice. When do you serve it? The short and simple answer is serve it right when you start work on a project. Because what happens with 20-day notices is they reach back 20 days. So if you have a project that you first furnish labor or material to on, let's say, August 1st, but you neglect to serve a 20-day notice until August 30th, well, the 20-day notice will reach back to August 10th, and then you would have lien rights for all the material that you furnished from August 10th going forward on the project, provided you comply with the rest of the preliminary 20-day notice requirements. But that period from August 1st to August 10th, you wouldn't have lien rights for. So as you can imagine, as you go further on in a project, and the longer you wait to serve a 20-day notice from when you start, the longer section of time and the potentially much larger um, um, the much larger section of your contract or portion of your contract you're not going to have lien rights for. So as noted in the statute here, those when 20-day notices is notified in the is identified here in the slide, those who serve 20-day notices and they wait after they first furnish labor material on the project, they're going to forfeit those lien rights for that portion of time where they're not served and they're not effective. And again, they only reach back 20 days. So long and short of it, serve your 20-day notice up front, right when you start work on the project, and make sure it has the correct estimate of your value of the labor materials you intend to furnish to the project, and monitor that with change orders, because at some point you may need to supplement your 20-day notice, and we'll talk about that. So step number 3 on that issue is supplement the 20-day notice if necessary. So you need to correctly state the estimate of the total price of the labor or materials to be furnished in your 20-day notice. That's one of the elements, requirements that be listed. And pursuant to A.R.S. 33-992-01H, a lien or a claimant's lien rights are limited to 130% of the amount in the 20-day notice. So for simplicity's sake, say there's a contract for $100,000 on a project, and you have change orders for $30,000. Well, because you have lien rights up to 130% of the estimate of the total price and the preliminary 20-day notice, you'd be covered. 130% of $100,000 is $130,000. You're fine. But if change orders increase the cost of the total cost of work on the project beyond that $130,000 amount, you need to supplement your 20-day notice to reflect the additional amounts, or you will not have lien rights for those. So as with the initial service of the 20-day notice, the supplement should be served within 20 days of furnishing the additional labor or materials. Again, it reaches back 20 days. And where I see people make mistakes and what you want to avoid is doing piecemeal supplementations. And that's where the initial amount of the contract is $100,000. There's a change order that bumps the contract amount to $140,000. And so in circumstances, some contractors will send out an original notice for $100,000 and a supplement for $40,000. And they'll put $40,000 in the section for the estimate of the total price in the supplemental notice. You want to avoid doing that. The estimate of the total price in the supplemental notice should be the aggregate of the labor and materials you're furnishing to the project, which in that case would be $140,000. So be careful with your supplementations and avoid piecemeal supplementations. Step 4 to getting paid quickly with contracts, bonds, and liens is to know your deadline to record a mechanics lien and to know your deadline to make a bond claim. On private projects, mechanics liens assert an ownership interest in real estate on the grounds that the claimant provided services or materials to improve the property but has not been paid. Liens cannot be recorded on public property. An owner-occupied residence cannot be liened unless the contractor or supplier has a direct contract with the owner. And if the project is being built for a tenant, the contractor or supplier may only have lien rights against tenant improvements. So those are the things to be mindful of, and limitations on lien rights on private projects. Because public property cannot be liened, federal and state law require payment bonds on project of certain types and sizes. And qualified subcontractors and material men may have claims against the payment bonds if they satisfy certain notice requirements. So big picture on private projects, lien rights except for certain particular situations in Arizona, and on public projects, no lien rights, but likely a payment bond is going to be required under the Federal Miller Act or the Arizona's Little Miller Act that you may have a claim on, provided that you satisfy certain notice requirements. We've covered this before in these webinars, but for purposes of recording a lien, generally you have 120 days after project completion. As set forth in A.R.S 33993C, completion usually occurs 30 days after a certificate of occupancy is issued. So on those projects where a certificate of occupancy is issued, you'd have 120 days from that certificate to record a lien. If no certificate of occupancy will be issued, completion occurs on the last day when labor and materials are furnished. So in that circumstance, you'd have 120 days from the last date that labor and materials are furnished to record your lien. If completion occurs if work stops for 60 days, and stoppage is not due to an act of God. So if a project is halted for 60 days, then that would be that 60 days would be 60 days from when the project is halted would be quote unquote completion, and then you have 120 days after that to record your lien. And the caveat on to these timeframes, and the only thing that can shorten up the time frame to record a lien is if a notice of completion is recorded. And then if that is the case, then the deadline to record a lien is 60 days after the notice of completion is recorded. The owner must, in that circumstance, provide a copy of the notice of completion to every person who served a preliminary 20-day notice. With respect to payment bond claims, and I'll go through these quickly, under the Federal Miller Act, laborers and material men with no direct relationship to the general contractor furnishing the payment bond must give written notice to the contractor within 90 days from the date on which the person did or performed the last of the labor or furnished or supplied the last materials for which the claim is made. So that's under the Federal Miller Act. Under the Federal Miller Act, there is no preliminary 20-day notice requirement, but there is a requirement that if you don't have a direct relationship with the contractor furnishing the bond, that you have to give them notice within 90 days of when you last did work or furnished materials to the project to that you're out there and you haven't been paid. Arizona's Little Miller Act, which is modeled after the Federal Miller Act, is a little bit different. A claimant who has a direct relationship with a subcontractor of the contractor furnishing the payment bond, but not a contractual relationship with the contractor, has a right of action on the bond on giving two notices. So in Arizona, if you don't have a direct relationship with the contractor furnishing the bond, the general contractor, you have to, number one, serve a preliminary 20-day notice. And that's the same notice that's required for lien claims that we talked about earlier. And then you have to give a 90-day post-completion notice saying the amount you're claiming and who the labor or materials were performed for. So in Arizona, the notice requirements on Little Miller Act bond claims are a little bit more onerous than on the Federal Miller Act bond claims, and that is all the more reason to have and make sure that you are in the habit of getting 20-day notices sent out when you start work on a project. Here's a chart of subs and suppliers protected by the Federal Miller Act and Arizona's Little Miller Act. And those subs and suppliers that have relationships with the general contractor, obviously the subcontractor here is protected. First tier suppliers are protected as well. The second tier subcontractors and suppliers are also protected under the bond claim, provided they give the correct notice. Third tier suppliers and second-tier suppliers in this situation, or a supplier to a supplier on a pure supplier side is not protected. Step 5, know your deadline to file suit to foreclose on the lien, recover against the bond, or assert a breach of contract claim. A claimant must sue to foreclose its lien claim within 6 months. If no foreclosure is filed within 6 months after the lien is recorded, the lien expires by operation of law. A payment bond claim deadline, you must wait 90 days under the Miller Act or Arizona's Little Miller Act after you last furnished labor and materials to the project to sue to foreclose or to make a claim on the bond, but you have a year from when you last furnished labor or materials to a project to sue on the payment bond. So you can't sue for 90 days after you first furnish labor and materials on a project, but then you have a year from when you last furnished labor and materials on a project to sue to foreclose. Statute of limitations on a breach of contract claim in Arizona on a written contract is 6 years, so you have more time. And that is the scope of our presentation for today. As always, Arizona statutes and case law relating to the construction industry are full of detailed technical requirements and exceptions, and this presentation cannot substitute for specific legal advice. If you have any questions or concerns relating to any aspects of mechanics liens, bond claims, construction contract, or prompt payment laws, please consult a qualified attorney. And with that, I'll turn it back over to Ariella and see if we have any questions.
We don't have any questions. You did a really great job, and I want to thank you very much, and I hope everyone has a sunny day.
Thank you, Ariella.
Thank you so much, Kevin.